Hello guys, my name is Gauri Bandre. I'm an intern at LEXIS and Company. My topic for today's discussion is adoption under Hindu law. Let us first start by understanding the background of adoption. Adoption was firstly restricted to only sons and not daughters. Why sons? Then sons have been given most important not only in ancient times but also in modern Hindu culture. Traditionally, the reasons behind adopting was very much restricted for religious purpose, like for performing rites or some mandatory ceremonies, etc., and not so much for secular reasons. Adoption was described as transplantation of a son from the family in which he is born into the another family by way of gift made by his natural parents to the adopting parents. What was mandatory? Only a boy can be adopted, and second, a boy belonging to your particular caste. Now if I'm a Brahmin, then I can't adopt you know a, a boy beyond my caste. It must be from my caste itself. But in modern times, everything got changed. So, after the enactment of Hindu Adoption and Maintenance Act of 1956, the religious aims and religious reasons were put behind, and the secular reasons were very much encouraged. And it was not mandatory for the people to perform some ritual or rites or homa to give and take of a child, and the restriction to adoption of only son was then replaced with that of child. So child means both son and daughter were considered now. So the new definition according to the modern Hindu law is an act of a person taking an infant child, both boy and girl, as his or her lawful child. This act of Hindu adoption and maintenance is only restricted towards India, and they don't have powers beyond its territorial jurisdiction. Also, it is not a retrospective law, it is only prospective law. Now, what does that mean? If I have adopted a child by performing some kind of ritual before the enactment of the law, then the adoption won't be considered invalid. It will be still valid under law, but henceforth, after the enactment of the act, nobody should perform the traditional means. They need to restrict themselves to method of adoption under the act. Now let us start by understanding who can adopt under this act. First, a person should be Hindu. Male or female should belong to Hindu religion. Who belong to Hindu religion? Anybody except Christian, Muslim, Parsi, or Jew will all be considered under Hindu. Second, who is deemed to have capacity to adopt. Now, the capacity to adopt is mentioned under section 7 and section 8. 7 for male and 8 for females. So, let us see what is the capacity mentioned under this act. First, for male is should be attained the majority age. Second, should be of sound mind. Third, if married, then consent of wife or all wives. Now, before enactment of Hindu Marriage Act, people had many wives. In that case, if you have more than one wife, then consent of each and every wife is mandatory. If even if one will reject, then this won't be considered as valid. Fourth, the consent of wife is not important if she has completely or finally renounced the world, or is deceased, or is divorced, or declared incompetent by court, or of unsound mind. Now, in case of the capacity of female under section 8, first should be of majority age, second should be of sound mind, third should be either widowed, divorced, or unmarried in order to adopt. If she is married, then she cannot adopt by herself. She needs to adopt through her husband, in which her consent will be mandatory, but she won't have the right of adoption. Now, the next question comes, who can give a child under adoption? This is covered under section 9, under which we will briefly divide it into three parts. First is only father, second is mother, and third is guardian. Now, why only father? If both the parents are alive, then the father has the right to give the child for adoption with the consent of mother. So the consent of mother is important, but only the father has the right if both the parents are alive. Now, second, if the father is dead or of unsound mind or has renounced the world or is deceased, then in that case the mother has the right to give up her child. Third is guardian. Now, in case of guardian, if the biological parents are dead or renounced or of unsound mind or have abandoned the child, then in that case only the guardian has the right to give the child for adoption, in which also the permission of the court is mandatory before giving it for adoption. Certain exceptions: one, the adoptive father and mother cannot give their adoptive child for adoption. The whole performance of this act shouldn't be based on money, because see, it is for the welfare of the child and it cannot be measured by money. If it is performed under exchange of money, then it will be considered invalid and void. Necessary conditions which we need to know is: one, in case of adoption of son, the adoptive parent should not have living son, grandson, or even a great grandson at time of adoption. Now, if in case have stepson, adoptive son, or illegitimate son living, then it is irrelevant. Second, in case of daughter, again everything is same, but they must not have living daughter, granddaughter or great granddaughter, etc. And again, illegitimate daughter, adoptive daughter, or stepdaughter is irrelevant. And in case if the female is adopting any male, then in that case she should be validated under the act. Second, there should be minimum gap of 21 years between the child and the female. Next, in case of male, again, if he should be validated under the law. And second, the minimum age between the daughter and the male should be of 21 years. Question comes, who can be adopted? This is mentioned under section 10. This states that he or she should be Hindu. Second, not already have been adopted. Third, he or she should not have been married unless there is any custom or usage. Fourth, should not be more than or of 15 years. Again, there is exception if validated under custom or usage. No child should be adopted simultaneously with two different families. Ceremony of Datta Homa, which was previously performed under Hindu religion, is not mandatory to be performed now, but there should be some kind of give and take between the birth family and the adoptive family. Next question comes, who is the adoptive father or mother? In that case, if the husband adopting any child, if he has any present living wife, then the living wife will be considered as a adoptive mother. If he has more than one wife, then the senior most wife will be considered as an adoptive mother and all others will be considered as stepmothers. Now, in case of female, again, the husband will be considered as adoptive father. If the husband is dead, then again the deceased husband will be considered as adoptive father. And if she is single, then in case if she gets married in future, then the future husband will be considered as stepfather, not adoptive father. The process of adoption will be validated. First, during the performance of the whole process of adoption, both the parents should be under the capacity to adopt under this act. Second, the person giving up should have the capacity to give a child for adoption. Third, the person who is being adopted should be of the capacity mentioned under this act. Last, it should be with the compliance of this whole act. Now, what is the effect of adoption? This is mentioned under section 12. Child is being transferred from the birth family to the adoptive family. He will lose all his rights from the birth family and will then occupy all the rights which a naturally born child will have if he was born in the adoptive parent's home. Moreover, the adoptive parent shall have all the potential obligations and rights which a normal parent would have. So there are certain restrictions which are mandatory to be followed. First is the child should not marry within the birth family as it is restricted under Sapinda relation. Second, if he is carrying an inherent property before the adoption, he will have the same continuance of that right and any certain obligations which is mentioned along with those rights will also be deemed as co-parcenary under the adoptive parents. Last but not least, the question comes, can a valid adoption be cancelled under this act? Then the answer is no. You cannot cancel a valid adoption, neither through the birth parents or the adoptive parents or even by the child. These were a few points which are mentioned under Hindu Adoption and Maintenance Act of 1956. Thank you.